The title of today's webinar is Career Alternatives for Physicists, Patent Law. I'm Crystal Bailey, and I'll be your host for today's broadcast. Thank you all so much for joining us. APS webinars are brought to you as a service of the American Physical Society, connecting you with the expertise of individuals who can offer insight into physics careers, educational programs, and professional development for students, working physicists, and educators. Today's presentation features Dr. Yeung Cheung and will be moderated by Arlene Modesti-Knowles. Dr. Cheung will be presenting information on features of patent law, possible roles of patent lawyers in university and corporate settings, and information on how to become a patent lawyer. After Dr. Cheung finishes the presentation, the remainder of the program belongs to you for our question and answer sessions. Because of the number of people attending this webinar, we are only accepting text questions. So if you would like to ask a question, please type it into the questions panel located on the right side of your screen. You can type those questions now, or you can continue to submit questions through the panel throughout the webinar. We will answer all of your questions at the end, so we will not be responding during the webinar. We'll get to everybody at the end if possible. We apologize if we are not able to cover everything. And finally, a link to the recording of today's presentation will be emailed to you after today's event. If you need to leave today's webinar early, we encourage you to complete the survey upon exiting so that APS webinars can improve its ability to provide you with these valuable services. And so with that, let's get started. So our moderator today is Arlene Modesti-Knowles. Arlene is the Career and Diversity Administrator at the American Physical Society. Arlene serves as the manager of the APS Scholarship for Minority Undergraduate Physics Majors, is on the leadership team of a new project, the Minority Bridge Program, and manages most other diversity programs for the APS. In her capacity as the Career Administrator at APS, Arlene has also organized and moderated career panels and tutorials at APS meetings, managed the job fairs and online career center, and worked on other career-specific programs. Arlene, would you like to take it from here?
Thank you, Crystal. Today we have Dr. Yeung Cheung joining us to talk about careers in patent law. And Dr. Yeung Cheung is an associate at the intellectual property law firm Myers Wolin, LLC in Morristown, New Jersey. He concentrates his practice in the area of physics, telecommunications, electrical and software, and focuses on the preparation and prosecution of patent applications, as well as patent infringement, freedom to operate, patentability, and invalidity analyses. He received his PhD in physics from Yale University and a JD from Northwestern California University. He is a registered patent attorney with the U.S. Patent and Trademark Office and is admitted in California and the U.S. Supreme Court. And with that, Dr. Yeung Cheung, there you go.
Thank you, Arlene. Thank you, Arlene, and welcome everybody. Today the topic of my talk is Career Alternative for Physicists, Patent Law. In this talk, I will first spend a couple of minutes to tell you how I became a patent attorney. Then I will talk about why patent law is a good career alternative for you and you should consider. I will then talk about what is a patent and why it is important. And then I'll tell you some possible jobs in the patent law field. They include patent agent, patent attorney, scientific advisor, technology transfer officer, and patent examiners. First, I'd like to just tell you a short story about how I became a patent lawyer. When I finished my physics PhD, I joined AT&T. At AT&T, I did product and service development. During that time, I made a few inventions and applied for patents for these inventions. That was the first time I had interaction with a patent lawyer and learned about their work. I find it very interesting, and so I began exploring this more. And to my surprise, I find out that you don't need to have a law degree to practice patent law in some aspects. And all of a sudden, it occurred to me that this is a possible career alternative for me. Later on, I took and passed the patent bar exam and became a patent agent and scientific advisor in a large law firm in New York City. At that time, I also looked into jobs as patent examiner and technology transfer officer. Later on, subsequently, I finished a law degree program and passed the California bar and became a patent attorney and joined my current employer, Myers Wolin. And that's a quick and short story about how I became a patent lawyer. Okay? And so you may ask why I want to be a patent lawyer. And you may also want to wonder what's in there, why it's good to consider a career in patent law. Personally, I think the most important thing about doing patent law is that I'm able to apply what I learned at school, my scientific knowledge, my physics knowledge. You're able to apply real-world applications to something that are interesting and important to scientists. As a patent lawyer, you never leave your science behind. Secondly, you will work with cutting-edge technology. Besides the inventor, you're probably one of the few people who learn it firsthand about the new ideas that inventor has. So you get to know something very new, very interesting, and also the variety of work. In a research career, you probably will be limited to a particular area of science. In patent law, you will have many clients, and they work in different technology, different fields. So you have a broader exposure to a wider range of science and technology. And also, you gain some legal knowledge. Law is rather fascinating, and you will have good opportunity to apply scientific facts in a legal framework. So all these are some of the good reasons that you should consider a career in patent law. And of course, patent is also a very important to business. Let me talk about, as a whole, patent law is a subset of intellectual property law. Intellectual property law basically include patents, copyright, trademarks, and trade secrets. The focus of the talk is patent. It's basically a grant that gives inventors sole right to use and sell an invention. Copyright is about the right to reproduce, publish literary, music, and artistical work. Trademark is symbols, trade name, and so on. And trade secret is something that you want to keep that from your competitor. But our focus is on patent. So what is a patent? Here, United States gives the inventor of the patent, the inventor, the right to exclude others from making, using, and offering it for sale or selling the invention throughout the United States or importing the invention into the United States for a limited time. So what does it mean? In other words, the patent holder enjoys a monopoly of the invention for a specific time. This is pretty powerful tool in terms of business strategies. Let me tell you a little bit about the scope of and size of patent work in the United States. You can see from 1996 to 2008, the number of patent applications increases dramatically. Right now, we have almost 500,000 patent applications each year. So you can see the amount of work and amount of interest in patent. And And there are many major companies actively sought out the patent and utilize their patent portfolio. For example, IBM, Samsung, Canon, Microsoft, Intel, etc. Those companies that have the most patent issued in 2008. So why do companies spend so much time and effort in acquiring a patent? Because of the values of the patent. For example, because you have control of the use and sales of your invention, you can license it to other business entities, and they will give you licensing fees. Alternatively, you can make it so unique that you are the only company that can offer such products and services. So you will have a monopoly position. And that also adds value to your company as new companies, new startups. That will be also an attractive investment. As you can see here, IBM currently have over 40,000 U.S. patents. And from those, IBM generates more than $1 billion each year just from technology licensing revenue. So you can see companies spend a lot of money and time on acquiring and enforcing and defending their patents. As a result, you can see that there are many job opportunities in patent law. So let me talk about patent law. Basically, it is broken down into two different areas, patent prosecution and patent litigation. Patent prosecution is the main focus of this talk. It's the process of obtaining a patent from the U.S. Patent and Trademark Office. For patent litigation, is about bringing a lawsuit against someone who might have infringed your patent. However, this requires special skills and knowledge of courtroom procedure. If you are ever involved in that, you probably be in the supporting role. A patent is infringed or violated when each and every element recited in a claim has identical correspondence in the allegedly infringing device or process. So that means it requires a lot of technical deep knowledge in order to analyze the patent and the product in order to identify that. And that's why a person who has scientific knowledge will have an edge over others in working in patent law. Most of the patent jobs fall into the category of patent agent and patent attorney. Most patent agent or patent attorney work for a law firm. Some work for large company institution. They have an in-house patent agent or patent attorney. The difference between patent agent and patent attorney is that patent agent is not an attorney. Patent attorney, of course, is an attorney. Both of them have to be admitted to practice before the U.S. Patent and Trademark Office. In order to be admitted, you need to pass the patent bar exam. Now, let me talk about the typical prosecution activities of a patent attorney. That basically is broken down into three parts. Patent application, office action, and infringement. When an inventor invented something, you will want to apply an patent application. That includes reviewing the invention disclosure, interviewing with the inventor, and preparing the legal documents, specification, claims, and drawings. Once you have your application sent in, it will be reviewed by the U.S. Patent and Trademark Office. The examiner will issue its finding, its opinion, called the office action. And part of the job of patent agent attorney is response to the office action. That includes reviewing the cited references that the examiner find that the examiner may say that that invention is not new, somebody already talk about that. You will need to prepare arguments and amendments. Sometimes you need to make changes to your claims. You may want to interview with the examiner. Sometimes if the examiner is not convinced and you think you're right, you can initiate an appeal. Those two patent application and office action responses can be done by patent agent and patent attorney. For the next one, infringement freedom to operate analysis, because it's like rendering legal opinion, a patent attorney should be doing that. You will be basically somebody may have infringed an inventor's patent. You will be asked to review the patent claim and look at the infringing product, see if there is a correspondence, and then advise the client of what options he or she may take. Okay? So that's pretty much typical type of work a patent attorney will do in the area of patent prosecution. As I said earlier, to become a patent attorney and patent agent, you must pass the patent bar exam. Okay? The patent bar exam is a one-day, 6-hour exam, 3 hours in the morning, 3 hours in the afternoon. There are 100 multiple choice questions, also 50 morning, 50 in the afternoon. You need to have at least 70% correct in order to pass. If you want to take the patent bar exam, you need to study the so-called the menu or patent examining procedure, so-called MPEP. All the answers can be found in that menu. So you may ask, what's the qualification for taking the patent bar exam? Here it is. Basically, it's a bachelor's degree in a recognized technical subject, or a bachelor's degree in another subject. However, you will have sufficient credits in physics, chemistry, or biology, or you may have practical engineering or scientific experience by passing a fundamentals of engineering test. And finally, you need to pay the examination fee. So that's the requirements for taking the patent bar exam in order to be a patent agent or patent attorney. Next one I want to talk about is scientific advisor. When the New York law firm hired me as a patent agent scientific advisor, they did not hire me for my patent law experience because I had none at that time. I just passed the patent bar exam, no experience in terms of patent prosecution. But for my scientific knowledge. In a law firm, scientific advisor help the attorneys in various tasks such as due diligence, litigation, and opinion. Because you hold the specific scientific knowledge, you will be asked to understand the technology and help the attorney understand it. Most law firms require the scientific advisor to hold advanced degrees such as PhD. Scientific advisor does not need to have passed the patent bar exam. However, many scientific advisors ultimately pass the patent bar, and some even pass the state bar exam and became an attorney. There are a few generous law firms that will subsidize law school tuition as well, if they really want you. So the next one that I want to talk about is technology transfer officer. many of the scientific discoveries made in university have some commercial values. It's good to the society and to the financial health of the university to commercialize their research work. Many major universities have a technology transfer office. As a technology transfer officer, you would help with the inventor and the lawyer to sort of as a liaison. Sometimes the lawyers may not understand the inventor, and the inventor scientists may not have time to explain to the lawyers or investors. So you will be asked to be the go-between. Sometimes the technology transfer officer may also act like a salesperson. You may have to market the university's intellectual property to private industry for further development and commercialization. So that's work in the technology transfer officer. And that's typically at a major research university. Finally, patent examiner. As I showed you earlier, there are almost 500,000 patent applications each year. The U.S. Patent and Trademark Office just cannot hire enough patent examiners to handle the workload. Currently, there's a huge backlog of cases waiting to be examined. So the U.S. Patent and Trademark Office is still actively looking for patent examiners. Patent examiner, as I said, will review the patent application and determine that whether they comply with basic rules and legal requirements. The examiner will research the subject matter claim in the patent application and determine whether that application is patentable, and will communicate the findings with the applicant or the inventor or the patent practitioner. Most of the time, the patent attorney, patent agent will act on behalf of the inventor or client and communicate and negotiate with the patent examiner. The requirements for being a patent examiner requires that you are a U.S. citizen because this is a federal job, a 4-year degree in engineering or science, and because the U.S. Patent and Trademark Office is located in Alexandria, Virginia, you are required to live and work in the Washington, D.C. metropolitan area. That seems to be a pretty tough, although I have heard about things that they are talking about having satellite offices in other locations, but there's no firm date on that yet. So as of now, you are still required to live and work in Washington and D.C. area. After you've been with a patent examiner for a while, you may be able to telecommute. Okay. So I just gave you an overview of the various types of jobs in patent law. This one is some web resources that I compiled for you. The first one is the U.S. Patent and Trademark Office website. There are a couple of professional organizations that you may want to consider joining. The first one is American Intellectual Property Law Association. The second one is National Association of Patent Practitioners. Most people in the NAPP, the National Association of Patent Practitioners, are patent agents. These two organizations have regular meetings and workshops and job postings and job fair for people who are looking for jobs in the patent law field. I also listed some websites that have specifically have patent law jobs. In addition, you can also try the monster.com, the standard law job site. Here are the intellectual property law server, job law patently O, and jobs law 360. These are good resources for you should you be interested in searching for a job in patent law. Okay. So I just gave you an overview of career possibilities in patent law, and hope that the information would get you interested and started exploring jobs in this area. And I wish you all good luck with your job search. Thank you for your attention and time. I'm happy to answer any questions now.
Thank you, Dr. Cheung. This is Arlene. We have some really interesting questions out there, so let's start with, you had mentioned that you only really need to have a bachelor's degree to apply to law school and become a patent lawyer. Is that correct?
You say that again, please?
You only need to have a bachelor's degree to have to become a patent lawyer. You need to have a bachelor's degree and then go to law school, and you can become a patent lawyer?
That's correct. You need to pass the patent bar exam and the regular state bar exam.
Exactly. And one of our participants would like to know, is it advantageous to have a master's or a PhD? Is it more advantageous than having just a bachelor's degree?
I would say so, because when you first started, you don't have much experience. As I said, a lot of law firms, when they hire you because of your scientific knowledge, not for your experience in patent law. Mm-hmm. So if you have an advanced degree, you will be very valuable right at the beginning to help them analyze the invention. At that time, at the same time, you will slowly get to learn about how to do the patent application and patent prosecution. So that will get you into the door easier, I think.
And what is the typical time frame for receiving the JD after the PhD? And is it possible to work in the field and also go to law school in the evenings?
Yes. If you go to law school full-time, it will take you 3 years. If you go to law school part-time, it will take you 4 years.
Okay. And while most PhD programs, at least in physics and applied physics, are funded, do you have any sense on how one can acquire funding for law school? And are there possibilities for doing both, the PhD and going to law school, to avoid substantial costs? Like, is there a PhD JD program that people could participate in?
I'm not aware of that. I am aware of JD MBA combined program, but I'm not aware of JD and PhD combined program. That I'm not aware of. But I would think that both are very demanding, so it might be very difficult for a person to pursue a PhD at the same time a JD degree. What I did is I did a PhD, and then many years later I got a JD.
And can you give the participants a sense of the costs for law school?
It can be very expensive. As you know, in the United States, it is cost of education is very high. So if that is a problem, I would suggest people to do a part-time program, and hopefully, if you at the same time work in a law firm which provides some sort of tuition assistance, that will help a little bit. One thing I want to mention, if you want to be a patent attorney, you can try to work also as a patent examiner. They also would give you time to go to law school in the evening. But I think in the difficult economic environment nowadays, there are not as many law firms in the past would sort of subsidize your tuition for law school.
Right. We have some other questions about citizenship. Is citizenship required to become a patent attorney or a patent agent or officer?
No, you don't have to, but you are required to be a U.S. resident. If you are not, if you pass the U.S. Patent and Trademark Office patent bar exam, you will be given a limited recognition, which is equivalent to a patent agent. You will still be able to practice patent law in front of the U.S. Patent and Trademark Office. But because you are temporary, that recognition is also temporary. If you are a permanent resident, yes, no problem with that.
Oh, that's good. We have quite a few questions on salaries.
Okay.
A lot of people want to know, what are the typical salaries or market salaries for patent agents or patent attorneys in a law firm? And yeah, I think basically typical salaries, if you can give a range.
I can give you a range. It basically varies based on location and experience. In terms of a patent agent, the median salary is about $70,000 to $80,000. For an attorney, it will be higher in the range of $100,000. For a patent examiner, it depends on your education and experience as well. They basically, it's a government salary grade, so you can look it up. It's also approximately $50,000 to $60,000 a year as a start. But of course, as a government employee, you enjoy a lot of the government benefits.
Okay.
What else? A scientific advisor is approximately the same as a patent agent. If you can find, it's rather limited to find a scientific transfer, a technology transfer officer's job in a major research university. That salary is typically over $100,000.
And do you need to have a PhD to be a technology transfer officer?
Not necessarily. However, a lot of those jobs would prefer you have an advanced degree for the same reason that you are required to communicate with the inventor or the scientist. They expect you to be able to understand what the invention is and be able to communicate that with the lawyer, the investor, outside industries.
Mm-hmm. I got a really good question here. What skills are important? What skills obtained in getting your PhD in the physical science, for example, physics, are most applicable to patent law work?
A couple of things. One is basic physics knowledge. When you work with a patent application, in order to be effective, you need to be able to understand what it is, be able to understand the science behind, and as well as communicating and convincing the examiner why this particular invention deserves a patent. So it requires you to have the basic knowledge in order to understand that, and also your ability to do some research. Sometimes you may, as I said, you will encounter a variety of technologies. You probably will not have seen it before, or you will need to do some research. And our training as a physicist, PhD, is that you need to do research. You will be able to apply what you learn and do a effective research and find out the essence of the invention. The important thing is to find out what's new, what's creative, what's important about that invention, and present that to the examiner and convince the examiner that this is really a good invention.
So a related question to that is, how is work in patent law similar or, more importantly, different than academic research? For example, research has freedom most often not found in other places.
In academic research, what you have quest for new knowledge. That new knowledge may or may not be of any commercial value, first of all. And second, the U.S. patent law does not automatically let you patent anything you find. It has to be of certain category. For example, you cannot, if you find a fundamental law such as E equals to mc squared, that cannot be patented because this is law of nature. The U.S. government decided that that belongs to everybody. It should not be belong to any particular person who just find out that law of nature first time. So there is a difference, and also there are, whether you want to patent something also depends on whether there's a commercial value. If you just patent something that you cannot make money out of it, it's not other than gaining some fame, you probably will not gain much out of it. A lot of people get patents because they believe that they can have some value. Otherwise, they won't spend that much money acquiring a patent. Acquiring a patent requires a lot of money and time, so it's an investment. If you do not do it wisely, then you will basically throwing the money away. So I guess that difference is whether there's commercial value or not.
Exactly.
And actual applications that people would find it useful and pay for it.
Someone wants to know, would a PhD or master's in other majors like chemistry or applied science also be beneficial in patent law?
Yes, definitely. There are a lot of industries that are specialized in one particular area. For example, drugs company have a lot of patents. Their drugs basically involves a lot of chemicals and biophysical interactions. Those people who have experience in chemistry, biology, molecular biology will have an edge in doing patent laws in those areas. For physicists, you will be more advantageous if you're dealing with areas of related to physics. For example, you may have you may work on lasers, semiconductors, related patents, while people with chemistry or biology experience will be more likely to practice in patents that are related to drugs and medical procedures, medicines, and so on. So yeah, it depends on your field, and probably then you will be working on patent in that particular areas and technologies.
Okay. And this is a really good question as well. If you pass the patent bar exam, can you practice law anywhere in the U.S., or do you still have to take the state bar exams as well?
If you pass the patent bar exam, you can practice patent prosecution anywhere in the U.S. If you pass the patent bar exam, you will be designated as a patent agent, and you will be able to represent clients in front of the U.S. Patent and Trademark Office and do the work that I said about regarding patent prosecution. That means drafting patent applications and responding to office actions. You do not need to have a law degree or reside in a particular area. One thing I'd like to point out that a regular attorney at law who passed just a state bar exam will not be able to represent clients in front of the U.S. Patent Office if they do not pass the patent bar as well.
So that is distinguished from the state bar exams, which allow lawyers to practice law, any kind of law, I assume.
That's right, yeah.
In other states.
In the state.
Right. Okay, and there's a question about what you do day to day. Day to day, do you spend your time explaining patents to others, researching on your own, or leading or working with a team of others? How do you spend your time as a patent attorney?
How I spend my time, usually I have a few cases that I work on at the same time. It could be, some would be responding to office actions, and some would be drafting patent applications. How I spend my time most of the time will be reviewing the office actions and then try to understand the examiner's argument and then do some research and understanding of what the main features of the invention, and try to find out how and arguments and suggestions and changes so that I can overcome the examiner's rejection. That requires some sort of research and studying of the patent and related arts. So it's similar to what you do in research, except that you will be doing it different areas for different case. Sometimes you will have to do a very deep understanding. Some may be rather broad, and also if I would need to draft a patent application, then I would have to review the disclosure made by the inventor. That sometimes can be challenging because the inventor may have just put down something on the back of a napkin paper, so you need to figure out what's going on. That is interesting, and sometimes you learn something about it, and doing some research, you gain some background, and then you want to talk to the inventor. That involves maybe meeting with the inventor at their location. They may show you the prototype, and so you can play with that too. And also, you may be asked to analyze some patents and see if some of the other competitors of the inventors are infringing their patents. Another thing is giving an opinion on whether a client who wishes to launch a new product or service and is afraid that he or she may have infringed other people's patent, and you will want to do a freedom to operate analysis and to help your client what to do. Basically, your work is between being a lawyer and being a scientist. I enjoy doing that because of the both aspect of it. So that's, I would say, is the typical work day for me, and it depends on how many cases I have to work on, what are the deadlines. So I have to rearrange my work if necessary. Sometimes something came up and you have to get the things filed by the deadline, sometimes maybe the day that you work on. So there are sometimes you have some rush, but most of the time you can pretty much plan your work because it's not a one-time process. It takes a little bit of thinking and planning, a lot of work to do a good job.
And
all right.
Someone asked in relation to what you do during the day, is it frowned upon to compile a large sum of patents as a patent lawyer and then pursue companies that are infringing upon those patents?
Yeah. There are companies who are not practicing the art, but they have a lot of patents in their portfolio. They are called in the industry, they are called the patent draw. They go after companies who may be selling or using some products that are infringing their patents, and try to get them to sign an agreement to license their patents. If not, then they will take them to court and try to force them to sort of come to a settlement. A well-known case in the past few years was a case about BlackBerry. A company called NPT owns the patent and filed a lawsuit against BlackBerry, and eventually forced BlackBerry to settle for $600 million. So you can see there are people who would think that those non-practicing entities who just hold portfolio patents and just try to lurk around and go after people who unknowingly sort of infringe their patents. Yeah, there are some words and say that not very good publicity in that area. But overall, I would think that patent is very valuable. The main idea is that you give the public, share your knowledge, your invention to the public, so that people can make use of it. In return, you get some compensation in terms of a limited monopoly. So as the U.S. Congress set up the patent system so as to promote the dissemination of scientific ideas. I think overall the society will be benefit from the patent system. Of course, as a patent lawyer, you want more people to apply for patents, so you get more work.
Sure. And this is an interesting one. Do you ever find that you can improve on the inventor's original concept, not just write a robust claim? And if so, how is this handled with the client?
Can you repeat that?
Do you ever find that you can improve on the inventor's original concept?
Yes.
And if so, how is this handled?
Okay. If you can, sometimes because your knowledge, you may be able to improve on your inventor's concept and make an improvement or better invention. All right. You now become an inventor. All right. However, as a patent lawyer, you have some fiduciary duty to your client. So because you derived the idea from your client, you probably need to assign that to your client, and pretty much the client will have the benefit of it. And of course, you can also negotiate with the client, see if he or she will give you some benefit or even allow you to be a co-inventor. Most of the time, we would not do that. We would just give the invention, even if you come up with the improvement, the credit goes to the inventor. You will, as a lawyer, you cannot really benefit from your client.
Right. On the career topic, what opportunities are there for career advancement? It sounds like to this questioner that patent examiners are sort of limited in their career advancement, but patent attorneys may have some ways to advance in their career. So what opportunities are there for career advancement? And I'm going to add on another question. Are opportunities more typical in just large cities, or are there really opportunities to study to be a patent lawyer in smaller cities?
Couple of things. As a patent examiner, yeah, it's a government job, and so you basically sort of move up a lot the ladder based on the salary grades and continue to move on. You started as an examiner, and then you can promote it to be a supervisor and so on. It's more structured, and in the typical law firm, however, you can work hard and get a lot of business and new clients. You can pretty much move up and make a lot of money and become a partner, and you have enough clients. You may be able to start your own business on your own. So the career advancement for a patent examiner is along the government ladder. In terms of in the law firm, it depends on how much you do, and sometimes if the more business you bring in, the better and the higher you can advance. In terms of cities, one thing though, a lot of major law firms, of course, reside in major cities, so you may be able to find more opportunities in large cities, New York, LA, and so on. However, there are a lot of law firms that are located throughout the U.S., and the good thing about technology is that you don't really need to be there in order to patent law or talk with clients. There are teleconferencing, email, and so on and so forth. So I would not think geographically you will be too much handicapped. However, in major cities, you will have more opportunity to interact with other people. So I would say yes, a large city will have some advantage. And of course, the living expense in the larger city is higher too.
Of course. We have time for one more question. So this participant wanted to know if you serve a small number of companies on a regular basis or a larger number of clients on a case-by-case basis. And in other words, do you deal with the same clients over and over again, or do you shop around for new clients often?
It all depends. We do have some major clients, big corporations, and so they have a lot of inventions. So we deal with those big clients on a regular basis, that they have a lot of cases that sent to us, and we will help them. So we do have a few of those clients that we do work regularly. And then there are some that are smaller ones that they may have only 1 or 2 inventions, and then you work with that. When it's done, you may not hear from them maybe many years later when they have a new invention. So it's a mix.
Okay. Well, I want to thank you, Dr. Cheung, for taking this time to give the presentation on career and patent law. And now I'm going to hand things over to Crystal.
All right. Well, thank you very much, Arlene and Dr. Cheung. Very informative presentation, and also a lot of really, really great questions. We, again, apologize if we did not get to your questions today. We welcome you to follow up with the speakers. You can either send an email to webinars@aps.org, and we will forward questions to Dr. Cheung for comment. And you can also find his contact information in his presentation, which will be available at our webinar homepage. You should be redirected there after today's presentation. You will also be receiving an email, a follow-up email with links to the video recording of the presentation and a PDF of Dr. Cheung's slides. Please stay tuned. In the coming weeks, we're going to offer more webinars, so we'll be sure to keep you in the loop about that. And if you have any questions, comments, or suggestions for future webinars, please email us at webinars@aps.org. And that's all we have today. We hope that you'll join us again next time. Thanks a lot.